The transgender agenda has been moving fast the last few years. That said, several states have moved to slow their progress, especially among our young people. One state, Tennessee, is being sued by the federal government. Oral arguments were heard by the Supreme Court in November. While the question posed to the court regarded a restraining order preventing the state from enforcing the law, a lot of time was spent on the primary question of the lawsuit. Does the Tennessee law violate the Equal Protection Clause of the 14th Amendment? So we'll look at that next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your rising generation be free. Glad you could join me today. Again, transgenderism has been a lot in the news lately. There's been a lot of pushes. You've got men participating in women's sports, men in women's locker rooms. A big question. And in the middle of this, as I said, several states have tried to step in the breach, Tennessee being one of them. Seeing as I am now a Tennessean, this is important to me. But there's a lot of good information in this case that I want to get to. I'm going to talk more about the website and other things you can do to learn more at the end of the episode. But for now, let's talk about the oral arguments in United States versus Skrmetti. Before we get into oral arguments, let's start with a little background. In March 2023, the Tennessee legislature passed and the governor signed a bill known as SB 1. In this bill, we find a healthcare provider shall not perform or offer to perform on a minor or administer or offer to administer to a minor a medical procedure if the performance or administration of the procedure is for the purpose of enabling a minor to identify with or live as a purported identity inconsistent with the minor's sex, treating purported discomfort or distress from a discordance between the minor's sex and asserted identity. As you would expect, this law was challenged in court. 3 transgender teens and their families sued, and the Biden administration Department of Justice sought an injunction to prevent the law from going into effect. The U.S. District Court for the Middle District of Tennessee granted the injunction, but the Sixth Circuit Court of Appeals stayed it. This led the Biden Department of Justice to appeal the Sixth Circuit's decision to the Supreme Court, which heard oral arguments on December 4th, 2024. As the petitioner, Solicitor General Elizabeth Prelogar opened with the arguments for the United States.
Mr. Chief Justice, and may it please the court. This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria.
Let's start with 2 truths and a lie. The first truth is that this law does prohibit the use of certain treatments for minors for the purpose of changing their body to appear different than their sex. The second truth is that the law claims to overrule the decision of the minor, parents, and doctors. The lie is one we're going to see a lot in these arguments, the concept of birth sex. But more on that later.
Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB 1 should be upheld so long as it's not wholly irrational.
There are many laws that place the state's view of what is best for a child above the decisions of their parents and others. The state also regulates the use of drugs and treatments. Now, this can be a tricky situation, having the state overrule the decisions of a parent. If the state can remove a child from their parents for the child's safety, though, why not prevent treatments that both the state and much of society find harmful to the child? In other words, is it irrational to protect children from drugs and other procedures that have long-term negative consequences?
That's wrong. SB 1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can.
Here's another lie, the idea of sex being assigned by someone. It's not like a baby is born and the doctor decides for themselves what sex to assign them. It's not like the doctor picks the baby up by the feet, goes into a drawer, and finds sex organs to stick onto him. They're not a Mr. Potato Head. A person's sex isn't even determined at birth, but at conception. When the sperm meets the egg, the sex is determined. It does not happen at birth, and it is not assigned.
If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care. But here, Tennessee made no attempt to tailor its law to its stated health concerns.
We will find that the plaintiffs and several of the justices will focus on sex, as if drugs cannot have drastically different effects when given to people of different sexes. It appears they believe there is no real difference between male and female. Again, more about that later.
Rather than impose measured guardrails, SB 1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB 1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify that sex-based line. Because the Equal Protection Clause requires more, this court should remand so that SB 1 can be reviewed under the correct standard. I welcome the court's questions.
Part of the petitioner's argument focuses on who specific drugs can be used on. This is a case of missing the forest for the trees, as we'll see later. Now, after giving her opening argument, General Preligar answered questions from the justices, the first of which came from Justice Alito.
General, can I ask you a question about the state of medical evidence at the present time? In your petition, you made a sweeping statement, which I will quote. Overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition.
General Preligar claims that there is overwhelming evidence that so-called gender-affirming treatment improves both the physical and psychological well-being of the patient. I say so-called gender-affirming care, since the care actually denies a person's gender in favor of their mental confusion. However, the Swedish National Board of Health and Welfare report that the risk of such care is likely to outweigh the benefits.
After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks.
A 1-2 punch from Justice Alito. First the Swedes and now the United Kingdom point out to the fact that the evidence that these treatments are beneficial are of questionable quality. I guess it's a question of who you should believe, an attorney or nation's Board of Health.
And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at.
Yes, there's a lot of debate about the effectiveness of these treatments, but let's not worry about all that. Could these treatments be medically necessary? Yes, and the law states it is not a violation of subsection A If a healthcare provider performs or offers to perform a medical procedure on or administers or offers to administer a medical procedure to a minor, if the performance or administration of the medical procedure is to treat a minor's congenital defect, disease, or physical injury. Which brings up another question. Is a drug or surgical treatment medically necessary for a psychological condition? This is where Justice Sotomayor started asking questions.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious
They
medical
think
condition.
some attempt suicide.
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
Do young people suffer from gender dysphoria? Yes. In fact, most of us suffer through puberty. Now, some adolescents even considered suicide. Again, the question remains, is the proper treatment for a mental disorder drugs and surgery? In response to one of the questions, General Preligar pointed out that one of the states that restricted access to such treatments used a more targeted approach.
West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that two different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
West Virginia chose a different path. They require two doctors to diagnose the gender dysphoria and mental health screenings. That was how West Virginia's elected legislators decided to deal with the issue. But should Tennesseans be forced to follow the same path? There's still the question of the medical necessity of drug and surgical treatments for mental disorders, especially when those treatments lead to infertility.
I do want to acknowledge that there is evidence to suggest that gender-affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility, so I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity.
Are using puberty blockers simply pressing pause on a person's puberty? Well, if that were true, then why would these drugs be used to chemically castrate sex offenders? Now, from my research, puberty blockers are used in women to treat endometriosis, but only for 6 months. A second 6 months treatment can be used, but only when supplemented with the female hormones estrogen and progesterone. While puberty blockers may pause puberty, what happens when a person's body passes the age where puberty can happen? If their body hasn't developed the ability to be fertile, then they are by definition infertile.
With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks.
Since the purpose of these cross-sex hormones is to prevent the development of the very things that make us male or female, I find it difficult to see how they cannot adversely affect fertility. Is it a question of the people remaining fertile or being made fertile with the use of more hormones? Next up was Chase Strangio, representing the respondents to the case. While there aren't many differences between Ms. Strangio's arguments and those of the Solicitor General, her main claim to fame is being the first declared transgender attorney to argue before the Supreme Court. That's right, Ms. Strangio presents as a man. Some people may be offended by that statement, but my purpose is not to offend, and I will use a person's preferred name. While the court may be willing to do so, I will not lie to you and claim this woman is a man. Since in the English language, the proper title for a woman of unknown marital status is Ms., that is how I'll refer to her.
Mr. Strangio?
Mr. Chief Justice, and may it please the Court. On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults too. By banning treatment only when it allows an adolescent to live, identify, or appear inconsistent with their birth sex, SB 1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
Again, we see the lie of birth sex, the focus on individual drugs rather than what they are claiming to treat, and the lack of concern for whether or not these drugs are the proper treatment for a mental disorder. One concern that Justice Alito did explore with Ms. Strangio is that of suicide.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies, that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
I do have a few concerns about Ms. Strangio's position here. One is the question of suicide versus suicidality, or thoughts about suicide. Suicidality is an emotional problem and therefore harder to quantify. Add to that the heightened levels of suicidality that come with puberty, and it's hard to differentiate whether the cause is puberty or gender dysphoria. I also wonder about the time frame for the longitudinal study she bases her position on. If someone is gender confused and expects a treatment to reduce their thoughts about suicide, there could be a placebo effect that I would expect to be short-term. Did these studies follow the patients for the years or even decades that would show a long-term solution? Compare that with the Cass report that looked at actual suicides, something that can be better measured, and I would think have a greater impact on a person's feelings, which can be managed without making life-altering decisions about one's body. Finally, we get to Tennessee's argument presented by J. Matthew Rice, Solicitor General of Tennessee, on behalf of Jonathan Skrmetti, the Attorney General.
Mr. Rice?
Mr. Chief Justice, and may it please the Court.
Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments. Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question. Half of the states, Sweden, Finland, and the UK, all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving medical issue. The Sixth Circuit should be affirmed. I welcome the Court's questions.
Does SB 1 discriminate based on sex or medical purpose? Wading through all of these arguments, that seems to be the core question. Plaintiffs say yes, respondents say no. Plaintiffs say sex, respondents say medical purpose. This led to a rather contentious debate between Mr. Rice and Justices Sotomayor, Jackson, and Kagan. I think Mr. Rice made an excellent point when he said,
but in this case, the only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological distress associated with her body. This is not only
what's your
different.
basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical? I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds being
I'm sorry.
asked.
I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.
As the lead petitioner, Solicitor General Preligar was allowed to rebut what had been argued before the court.
But I think it's important to recognize that my friend's arguments would equally apply to a nationwide ban if this were enacted by Congress. And so I think that the court should keep that in mind when thinking about the level of scrutiny here.
The problem with this argument is that Congress is not constitutionally authorized to regulate medical treatments. That hasn't stopped them in the past, but it should at least be pointed out here. And really, is the question any different for a state law versus a federal one? In my opinion, this argument's a misdirection.
Finally, I think the court should think about the real-world consequences of laws like SB 1. Consider its effects on Ryan Rowe. As Justice Sotomayor noted, Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care, and they say this is about protecting adolescent health, but this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity. And the state says it doesn't even want the courts to take a look at whether this protects adolescent health, but the reason Ryan can't have these medications is because of his birth sex, and a sex-based line like that can't stand on rational basis review.
Again, the role of the court is not to consider the consequences of a law. That's the role of the legislative branch. The court is there to apply the laws to the controversy before them. Justice Sotomayor similarly used a young woman who wants to live as a boy to make an emotional argument rather than a legal one. What the justice described, and the Solicitor General repeated here, are the effects of a mental disorder. Her nausea and psychosomatic muteness were not caused by a medical condition or a problem with her body, but a problem with her mind. Yet before she reaches the age of consent, her parents and her doctor wants to put her on drugs, the long-term use of which can cause serious medical harms, and that is just for the puberty blockers. If Ms. Rowe truly wishes to modify her body to look like a boy, she'll also have to take testosterone, which in women causes hyperandrogenism, atrophy of the lining of the uterus, blood cell disorders, and an increasing risk of heart attack. There was a lot more in the oral arguments I could have talked about, but I think this episode is long enough, and I did cover what I think are the most important points. The claims of both the United States and the petitioners is that since Tennessee prohibits them from receiving the same drug as a person of the opposite sex, the law is sex discrimination and requires heightened scrutiny to pass the court's review. However, they ignore the fact that the prohibition in the law do not restrict drugs from someone because of their sex, but because of the effect they would have on their body. Several court watchers I follow believe the majority of the court seemed favorable to Tennessee's position. As usual, we'll have to wait until the court releases its decision, probably in June. Regardless of how the court finds, I think it was a worthwhile exercise to review the arguments from both sides. This allows us to see which side seems more anchored in the facts and law, and which side seems more interested in emotions. So that's the case of United States versus Skrmetti. Probably, even though it only deals with a restraining order and not the actual facts of the case, I think it's going to be one of the bigger cases, more important cases the court has dealt with, especially when they release their decisions in June. So when I expect this decision to come out. Is this the end of the argument? It's the end of the road? No. Because regardless of what the Supreme Court comes up with, that is about a restraining order. They may give guidance back to the Sixth Circuit about the quality of the evidence and the quality of the case and should they lean one way or the other. But it's going to go back to the Sixth Circuit, and there's going to be a decision there. And most likely that's going to be sent back up to the Supreme Court, asked for a review again. So this isn't ending anytime soon, at least not in my mind. Now that means we'll be back here to talk about this, but it means there's more opportunities for us to learn. And learning is a big part of the Constitution. We want to help people learn to read and study the Constitution. I found a course that will help. It's called The Miracle of America. It looks at the history of the Constitution and then the Constitution itself. It helps explain why the Constitution is the way it is, why certain things are the way they are. And I found it very helpful. Now, I made a deal with the owners for you to get a free lesson, a sample, so to say. Just go to constitutionstudy.com/1776 study guide. That's the numerals, 1776 study guide. You'll be taken to a custom landing page just for Constitution Study listeners, and you can check out the course, but you can also enroll for your free lesson on God's natural law. Whether you're interested in the course or not, I'd recommend at least taking the free lesson. I think you'll find it interesting. Again, go to constitutionstudy.com/1776 study guide to check it out and enroll for your free lesson. And if you also want to support the Constitution Study, how about using your cell phone? That's right. Patriot Mobile is America's only Christian conservative wireless provider, and they are helping the Constitution Study. So go to patriotmobile.com/constitution, see if there's a plan that works for you. The prices I found are pretty good. There's discounts for multiple families, for NRA members, for first responders, and their customer service has been great. Their coverage across the country, excellent. I haven't had any problems with it at all. It's been a wonderful, I've been a customer of theirs for a couple of years, been very happy with it. By the way, if you use the code Constitution at checkout, they'll even activate your plan absolutely free. So please go to patriotmobile.com/constitution, find a plan that works for you, stop sending your money to companies that are antagonistic to our rights. Send to a company that will help support organizations that protect our rights to freedom of religion, freedom of speech, simply to life, liberty, and the pursuit of happiness. Now, I hope you liked what we dealt with here, and if you've got any suggestions or any questions, just go to constitutionstudy.com/questions and ask. I love answering questions, and I'll give you the best information I have. But most of all, I hope you find some friends and family to bring with you next time for the Constitution Study.
Love your neighbors and have a few good friends.